Why did you do this? You gave up the right to remain silent. Why did you do this? That's your daughter. I mean, it's bad even if it wasn't your daughter, but why would you do that to your daughter? 2024 CR 0122220, State versus Alexander Aguilar. Can I have parties announced?
Opinion for the state of Texas.
Kyle Simpson for Mr. Aguilar.
Are you Mr. Aguilar?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Aguilar, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
And did you review that with your attorney?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
No, Your Honor, state will proceeding on count 5 of the indictment and will waive the other counts.
Any objection?
None.
Additionally, Your Honor, state will waive the habitual offender enhancement.
Objection.
And I'm sorry, are you waiving? Oh, and you're waiving count 6. All right, so for the record, the state is waiving the habitual enhancement allegations, counts 1, 2, 3, 4, and 6. Is that correct?
Correct. Yes, Your Honor.
And you're proceeding on count 5?
Yes, Your Honor.
All right. Any objections to those waivers?
No, Your Honor.
Mr. Aguilar, did you review the court admonishments with your attorney? Did you understand it?
I did.
Did you sign it in all the appropriate places? Did you understand you're charged with assault of a, that's a second-degree felony? Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you are giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Aguilar, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 5. Punishment is to be assessed at 16 years in the prison. There's a $1,500 fine, no applications. There's an affirmative finding of family violence. There's to be no contact with the complainant and lifetime sex offender registration. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
It is.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No.
Then to count 5, how do you plea?
No contest.
State, any evidence?
At this time, state offers the evidence is Exhibit 1 with all attachments.
Without objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, why is there an estimated range in here for, it says DLB or estimated age range?
I believe it's because initially she filled out a pseudonym form.
Okay,
That's at the back of the stipulations, Your Honor.
all right, thank you.
You're welcome.
I was calculating the age and I said, just bring out the age calculator.
Yes,
Yes.
All right, so why should, the court is going to find there's sufficient evidence to find you guilty. Court will find you guilty. Why should the court follow this agreement?
That's what the victims wanted, Your Honor. I've spoken with both her and the mother. They're okay with it.
All right, and currently I believe she's 17.
Currently, yes, Your Honor.
All right, anything you want to say?
Mhm.
Why are you doing this?
Excuse me.
Why did you do this? You gave up the right to remain silent. Why did you do this? That's your daughter. I mean, it's bad even if it wasn't your daughter, but why would you do that to your daughter?
Ma'am. And then
I mean, have you internalized what you've done?
there's no,
And I can't believe the mother allowed you into the home with your criminal history anyway. And when you came back into the home after you're being in prison, did you have the gang tattoos as well?
there's no,
And she still allowed you in the home.
we weren't together.
It was his own.
All right, so it was his home
So,
where this happened. And somebody allowed their daughter to go and stay with you, and you're a gang member, and you've been to prison. All right. The court is going to sentence you to 6 years in the prison. I'm sorry, 16. Thank you. 16 years in the prison. There's to be a $1,500 fine. Credit for any time served. There's to be no contact with the complainant. There's to be Chapter 62 registration. There's an affirmative finding of family violence. There's to be no contact with minors ever. There's to be no residing in any household with minors. So you're not allowed to reside or live with anyone who has children in the household. Do you understand? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? We can go off the record. So for the rest of your natural life, you're not to reside in any household which the court is calling 2024 CR 011984 State versus Daniel Montoya. Could I have parties announced?
Ashley Jones for the state.
Arlene Gay for the defendant.
And are you Mr. Montoya?
Yes, ma'am.
All right, this is what I'm going to do. I know that previously we had the plea, and then there was some question of maybe he's not competent.
Correct.
So I think it would be best so that the record can be clear. We will just do the entire plea over again as far as me going over his rights with him, because now it's 100% certain that he is competent.
Okay, I think that's fair.
All right. I'm sorry, can I have the file stamp back? Yes.
Okay.
And it's just so that we can make sure that the record is clear, okay? And what I can tell you, whatever plea bargain agreement that you all had previously worked out, I know that I was intending to follow it until we stopped in the middle of the plea, okay? All right, court is calling 2024 CR 011984 State versus Daniel Montoya. Could I have parties announced?
Ashley Jones for the state.
Arlene Gay for the defendant.
And are you Mr. Montoya?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Montoya, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
All right. Counsel, do you waive the reading of the indictment?
Yes, we do.
All right, and I do have an application for deferred adjudication, but he is not applying, is that correct?
That is correct. We are asking the court to sentence him to the 2 years, and I've discussed this with him multiple times, discussed it with him today, and that is what he wants to do.
All right.
Is that true?
Yes, ma'am.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, you're charged with aggravated assault with a deadly weapon. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
The plea will be
All right, let me go over it again. So right now, what I'm going to do is I'm going to tell you what your rights are, and I want to make sure that you know what your rights are. So do you understand that you have a right? Let me go back a little bit. Here you go, counsel. Do you understand that you're charged with aggravated assault with a deadly weapon?
Yes, ma'am.
All right, the range of punishment for that is anywhere from 2 to 20 years in prison. Do you understand?
Yes, ma'am.
And it's up to a $10,000 fine.
Yes, ma'am.
My understanding is that you've reached an agreement with the state for 2 years in the prison. Is that correct?
Yes, ma'am.
I don't have to follow that agreement. Do you understand that? No. Here's the thing. No. I want you to listen, okay? Breathe. All right. I don't have to follow that agreement. So let's say I don't follow that agreement and I say I want to give you 3 years, right? Not saying that's going to happen, but let's use that as an example. If I were to do that, you can withdraw your agreement and say, well, we don't have an agreement because I agreed for 2. You understand?
Oh, yes, ma'am.
All right, so that's what I mean. So I don't have to follow your agreement. If I don't follow your agreement and I try to give you more than 2 years,
I'm gonna say no.
you're going to say no, right?
Yes.
All right, so you understand that.
Yes, ma'am.
All right, you have a right to a jury trial. So 12 people would sit on the jury. The state would have to present their evidence. They would call witnesses and your attorney would get a chance to question them. All right. You also, the state couldn't turn to you and say, hey, now we're going to call Mr. Montoya to the witness stand. They wouldn't be allowed to do that because you have a right to remain silent. Do you understand?
Yes, ma'am.
All right. If you enter into this plea bargain agreement, you're giving up those rights. So what that means is the state is not going to call any witnesses. You understand?
Yes, ma'am.
And that means that if somebody wants to call you to testify to something, they can because you're saying you're not going to remain silent if somebody wants to ask you questions. Do you understand?
Yes, ma'am.
Now, by entering this plea, you're agreeing to all of that. Do you understand?
Yes, ma'am.
And do you agree to all of that?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
And did you have him evaluated for competency?
Yes, I did.
And the results?
He was found competent.
All right, Mr. Montoya, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than this plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. There's a $500 fine. There's an affirmative finding of deadly weapon, and there's an affirmative finding of family violence, and there's no application for deferred adjudication. Did you understand that?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
And did you understand you're not allowed to be designated as primary custodial parent? Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes,
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? This paragraph.
Yes, ma'am.
Did you understand it and sign it in both places?
Yes.
All right, so by signing that, what's happening is you're giving up your right to appeal. Your
Okay.
right to say, you know what? I don't like that deal. Now that I've had a chance to think about it, I changed my mind. You're giving up that right. You understand?
Oh, yes, ma'am.
Now, there are certain things that you can still say you want to appeal on. For example, if your attorney has filed some sort of pretrial motions, I've heard it, I've ruled on it, you can still appeal as to that. Do you understand?
Yes, ma'am.
Counsel, have there been any such motions?
no, there has not.
All right, then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State would offer State's Exhibit 1 in all attachments.
No objection.
And state, have you spoken to the complainant?
Yes, Your Honor.
All right, state you may be excused.
Thank you, Judge.
Did you review the waiver? This packet with your attorney? It has the police reports and everything in it.
Yes, ma'am, she did.
All right, did you understand it and sign it?
I think I did.
All right, so let me show you. Is that your signature?
Yes, ma'am.
Okay,
Your Honor, if the state may just make a comment
sure.
on the previous plea that we did, the state waived count two. I forgot to go through that again.
All right, okay, thank you.
Yes, Judge.
Any objections to
No,
count two?
No objection.
All right, so again, you have a right to a jury trial. Right for you or your attorney to question any witnesses the state would call, and the right to remain silent. By entering into this plea, the state is going to give me evidence on this case, but that evidence is going to come from police reports and witnesses' statements. So nobody's going to come in and testify. I'm just going to read this document and see if there's enough evidence in here to find you guilty beyond a reasonable doubt. Do you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We're just asking the court to follow the plea bargain and also that time and money run concurrent.
All right, so with regards to the parties involved, they appear to be all related.
Yes, a brother and a sister.
So there may be a need for no contact. What's going on with that?
Um, uh, that was the problem with this case initially on bond, is that he lived with his grandmother a bit. His
Mhm.
brother and sister lived, I think they were allowing 1,000 feet,
Mhm.
and they lived within that 1,000 feet. But I believe from just discussions that everybody's kind of made up, Your Honor. He will go back and live with his grandmother. My client is mentally ill. And so that's who kind of takes care of him, and they take care of each other.
All right.
But, and the sister who was involved in the brother, they've spoken to the district attorney's office. So
All right. And state with regards to the no contact, are you requesting no contacts or no?
The state is requesting a no contact, Your Honor. Understanding defense counsel's position, but this was a case where a deadly weapon was involved. So I will proffer to the court that at least, you'll give me one moment, the complainant with the first name of John has informed us that he wants a no harmful or injurious contact order. And just a moment. I don't have what the complainant Ramona would want, but she did recant.
she's been very vocal, to say the least, in favor of trying to assist her brother as opposed to assisting the state.
That is correct, Your Honor.
And they don't have parents, so grandma is the person in their life. And I think no harmful or injurious would be appropriate. Because without him being able to go live at grandma's house, he doesn't have a place. And this case kind of proved it when we were trying to get him out on bond, and he had no place to go. And they put him in Lifetime, and he did do the program at Lifetime Recovery. We assisted him with his mental health and also assisted him with alcohol addiction. So he did complete the Lifetime Recovery program during the pendency of this case.
Okay. All right, this is what the court is gonna do. The court is gonna find you guilty. There's an affirmative finding of family violence, an affirmative finding of deadly weapon. There's a $500 fine, time and money run concurrent. There's to be no harmful or injurious contact with Ramona Montoya and John Montoya, and the court will recommend the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, when you were, yes. Oh, thank you so much. 2 years prison. You would go off and they would say, there's no term. So you're sentenced to 2 years in prison. All right, so we can go off the record. Mr. Montoya, when you're released, it's probably best for you to go to the Center for Healthcare Services, make sure you have your medications, whatever you need. And if there's an issue, if you don't have a place to stay, when you're released, if I am still here, I will make sure that I find a place for you. Do you understand?
Yes, ma'am. I stay at heaven for hope.
Okay. All right, good luck to you, okay?
Thank you, ma'am.
Alexander Aguilar appeared before Judge Boyd on a no-contest plea to sexual assault, a second-degree felony, with punishment assessed at 16 years under a plea agreement. The state waived the habitual offender enhancement and multiple additional counts. No application for probation was sought. The central issue Judge Boyd focuses on immediately after accepting the plea is not the procedural record. It is the relationship between the defendant and the victim, which the stipulations confirm. The hearing turns when Judge Boyd asks directly why he did this and names the victim as his daughter. The question is not asked to elicit a useful answer. It is asked to ensure the defendant confronts, on the record, the full nature of what he pled to. His response, silence, is itself significant. It neither offers remorse that the court could evaluate as genuine nor provides an explanation that might inform sentencing. Judge Boyd's follow-up observation that it would be wrong even if the victim were not his daughter establishes that the familial relationship compounds rather than explains the conduct. The 16-year sentence follows the agreement, but the conditions extend beyond confinement. Lifetime sex offender registration addresses the permanent public safety concern created by this offense. The prohibition on contact with minors and on residing in any household with children solves the problem the offense itself revealed. The defendant used access to a child in his home to commit the assault. The affirmative family violence finding restricts firearm possession permanently. This hearing ultimately demonstrates that Judge Boyd's courtroom does not allow a plea agreement to proceed without the defendant being made to understand in plain language what they actually did and to whom.